What if holding two passports suddenly put a target on your back? Imagine landing at a US airport after a normal trip overseas and being pulled aside because a system now shows something you never knew you were required to report. A second passport you've had for years. A foreign bank account you assumed was irrelevant. A form you didn't even realize existed. And suddenly you're facing fines, travel delays, or even questions about your citizenship status. Starting February 2026, major dual citizenship law changes are coming into effect that will affect millions of Americans. These new rules introduce mandatory registration, strict reporting requirements, and far deeper tracking of dual citizens than ever before. Miss one deadline, forget one disclosure, or assume the old rules still apply. And the consequences could include thousands of dollars in penalties, blocked passport renewals, enhanced airport scrutiny, and serious complications with taxes, careers, and family immigration. Most dual citizens have no idea this shift is happening because it isn't being loudly advertised. On the surface, it looks like routine administrative updates. But behind the scenes, the US government is moving from a loose trust-based approach to a centralized system that tracks, cross-checks, and connects information across agencies in ways that have never existed before. And once February 2026 arrives, there won't be grace periods for ignorance. The window to prepare is closing fast. In this video, you're going to learn exactly what is changing, who these new laws apply to, what deadlines you must meet, and how to protect yourself before these rules quietly turn into real-life problems. If you hold dual citizenship, are thinking about becoming a dual citizen, or have family members who do, this information could save you from serious headaches in the near future. Hi, I'm Timothy, and I cover U.S. immigration and citizenship updates so regular people can stay ahead of policy changes before they turn into personal problems. I want to be clear right from the start. Nothing you're about to hear is speculation or online rumor. These February 2026 changes are already moving through official implementation, and government systems are being built to enforce them. My goal here isn't to scare you. It's to give you clarity, practical guidance, and a clear roadmap so you know exactly what to do and when to do it. Dual citizenship is still completely legal in the United States, but the responsibilities that come with it are about to become far more formal and far more visible. And understanding those responsibilities now is the difference between staying fully protected and getting caught off guard later. To understand why these changes matter so much, we need to step back and look at how dual citizenship has traditionally worked in the United States. For decades, the U.S. has taken a mostly hands-off approach to people who hold more than one nationality. Unlike some countries that force you to give up your original citizenship when you become American, the U.S. has generally allowed dual citizenship to exist without much interference. As long as you followed basic rules like using a U.S. passport to enter and leave the country and paying U.S. taxes, you could live a normal life without ever formally declaring your second citizenship to anyone. In practice, the system relied heavily on trust and self-reporting. Different government agencies didn't always communicate with each other, and most dual citizens were never asked to provide detailed information about their other nationality. For millions of people, dual citizenship was simply a private part of their identity, not something the government actively tracked. But that quiet era is coming to an end. What's happening now is not a ban on dual citizenship. Instead, it's a shift toward visibility, documentation, and enforcement. The government is building a centralized structure where immigration records, tax filings, travel data, and security databases can all connect and cross-reference information. Actions that used to stay in the background, like using a foreign passport, maintaining accounts overseas, or spending long periods abroad, are about to become much more visible to multiple agencies at once. This new approach reflects a broader trend toward tighter border security, financial transparency, and national security oversight. And while most dual citizens have done nothing wrong, the rules are changing in ways that will require far more attention and far more paperwork than ever before. Understanding this shift is critical because every new requirement coming in February 2026 is built on this new mindset of tracking and accountability. Now, let's talk about the single biggest change arriving in February 2026. The new mandatory dual citizenship registration requirement. For the first time in U.S. history, every American who holds citizenship in another country will be legally required to register that status with the federal government. This is not optional, and it is not something you can ignore. Beginning on February 1st, 2026, a new online system managed by the Department of Homeland Security will open, and dual citizens will have exactly 6 months until August 1st, 2026, to complete their registration. This requirement applies to everyone. It doesn't matter whether you were born with two nationalities, gained a second passport through marriage, or became a U.S. citizen and kept your original citizenship. If you legally hold citizenship in more than one country, you must register. The information required will go far beyond anything most people have ever submitted before. You will need to provide details about which countries you hold citizenship in, passport numbers from those countries, travel history, any foreign government employment, previous military service abroad, and other background information that helps create a full picture of your dual status. And the penalties for failing to register are serious. Missing the deadline or refusing to comply can result in fines of up to $5,000, delays or denials when renewing a U.S. passport, problems at border crossings, and complications with future immigration or government processes. What makes this even more significant is that this registry will not exist in isolation. It will be connected to other federal systems. That means border officials, tax agencies, and security departments will be able to instantly see whether you have registered and whether the information you provided matches your real-world activity. If travel records, tax filings, or previous applications don't line up with what you submit, that inconsistency could trigger audits, additional screening, or legal issues. In other words, this is not just another form to fill out. It is the foundation of an entirely new way the U.S. government will monitor and manage dual citizenship. For anyone affected, the smartest move is to take this seriously from day one. Gather your documents early and be fully prepared before the registration window even opens. Waiting until the last minute could be one of the most expensive mistakes a dual citizen can make. If you work in certain professions, these February 2026 changes go even further. Dual citizens employed in sensitive fields are about to experience a level of scrutiny that many have never faced before. Federal employees, defense contractors, intelligence community workers, and people in critical infrastructure roles will be held to stricter reporting standards than the general public. Under the new framework, simply registering your dual citizenship will not be enough. You may also be required to disclose detailed information about close family members who hold foreign citizenship, including spouses, parents, siblings, and even adult children. Financial ties abroad will come under sharper focus as well. Ownership of property in another country, foreign bank accounts, business interests, or regular financial support sent overseas could all become part of formal reviews. Even routine interactions with foreign government officials connected to your other nationality may need to be reported depending on the sensitivity of your position. None of this automatically means you've done anything wrong, but it does mean that transparency is no longer optional. Security clearance evaluations, background checks, and employment reviews will now have access to far more interconnected information than before. For some dual citizens, this could lead to longer clearance processing times, additional interviews, or restrictions on certain assignments. In rare cases, it could even affect career advancement opportunities in highly sensitive roles. The key point to understand is that these changes are not designed to punish dual citizens. They are designed to remove uncertainty and close gaps that previously existed. But for professionals in these fields, waiting to see what happens is a risky strategy. If this applies to you, the smartest approach is to be proactive. Speak with your security officer, compliance department, or human resources team before these rules take effect. Make sure your records are accurate and up to date. Address potential concerns early rather than being forced to explain them later under pressure. In environments where national security is involved, preparation and honesty will always work in your favor. Another area where dual citizens will feel the impact almost immediately is international travel. Beginning in February 2026, U.S. Customs and Border Protection will have direct access to the new dual citizenship registry, and that will change how many people experience entering and leaving the country. To be clear, dual citizenship itself is not becoming illegal, and traveling with more than one passport is not being banned. What is changing is how closely travel patterns will be monitored and analyzed. Border officers will now be able to see in real time whether you have registered your dual citizenship and whether the information you provided matches your actual behavior. If you frequently travel on a foreign passport, spend long stretches of time outside the United States, or regularly move between two countries, those patterns may trigger additional questioning when you return. For example, if a dual citizen spends more than 6 months of the year abroad, especially in their other country of citizenship, officers may ask detailed questions about where they truly live, where they work, and whether they maintain strong ties to the United States. These conversations won't necessarily be hostile, but they will be more thorough than in the past. The government's growing concern is whether someone is an American citizen in practice, not just on paper. This matters because travel history can affect more than just border experiences. It can play a role later if you sponsor family members for immigration, apply for government benefits, or undergo security screenings. The good news is that most problems in this area can be avoided with simple preparation. Keep clear records of your U.S. residence, employment, tax filings, and financial connections. Travel with documentation that shows your ongoing ties to the United States. File your taxes correctly and on time. If questioned, be ready to calmly explain the reasons for your travel patterns. None of these steps are complicated, but under the new system, they become far more important. The message here isn't that travel will suddenly become dangerous for dual citizens. It's that casual, undocumented travel habits that never mattered before could now create unnecessary complications. And understanding that shift in advance gives you the power to stay in control. Where the government is becoming far less flexible is in the area of taxes. Technically, the tax rules for dual citizens are not new. For decades, every U.S. citizen, no matter where they live or what other passports they hold, has been required to report worldwide income to the IRS. But what is changing in February 2026 is how aggressively those rules will be enforced. The United States is expanding financial information sharing agreements with banks and tax authorities around the world. That means foreign accounts, overseas investments, rental properties, and international business income will no longer be as hidden from U.S. authorities as they once were. If you are a dual citizen with financial ties outside the United States, the era of assuming no one will notice is effectively over. One requirement that continues to surprise many people is the foreign bank account reporting rule. If the total balance of all your foreign financial accounts ever exceeds $10,000 at any point during the year, even for a single day, you are required to file a separate report known as an FBR. This is not part of your normal tax return. It is an additional disclosure that many dual citizens have never even heard of. Failure to file this report can result in penalties of up to $10,000 per violation per year. In more serious cases, the penalties can be much higher. The major shift coming in 2026 is that the new dual citizenship registry will be cross-checked with IRS records and FBLR filings. If you register as a citizen of another country, but your tax history shows no foreign income and no foreign account reporting, that mismatch could quickly raise red flags. Audits and compliance reviews are expected to increase significantly. This doesn't mean the government is trying to trap people. It means the system is finally being connected in a way that makes non-compliance easier to detect. For dual citizens who may have fallen behind on these obligations, now is the time to act, not later. There are legal programs designed to help people correct past mistakes and come back into compliance without facing extreme penalties. Speaking with an accountant or tax professional who understands international tax law could save you enormous stress and money. The key lesson is simple. Under the new system, hoping the government won't notice is no longer a strategy. Transparency and preparation are the only safe paths forward. Another area that deserves serious attention involves foreign military service. For many dual citizens, especially those connected to countries with mandatory service requirements, this has always been a complicated subject. In the past, serving in a foreign military did not automatically put U.S. citizenship at risk. The government generally had to prove that a person intended to give up their American citizenship. But beginning in February 2026, that standard is becoming stricter. Under the new policy direction, voluntary service in a foreign military, particularly in combat roles or as an officer, may create a presumption against the individual. Instead of the government having to prove you intended to relinquish your U.S. citizenship, you may now have to prove that you did not. That shift in burden is significant. There are still important exceptions. Compulsory service required by law in another country is usually treated differently, and non-combat roles in allied nations may not create major issues, but the gray areas are where problems arise. Taking an oath to a foreign military authority, accepting rank, or participating in certain operations can all become factors that raise serious questions later. Starting in 2026, any prior foreign military service will also need to be disclosed during dual citizenship registration, and that information can affect security clearances, government jobs, and even future immigration matters. If you are a dual citizen considering military service abroad, or if you have already served in the past, this is not something to assume will work itself out. Getting proper legal guidance before making decisions in this area can prevent consequences that are extremely difficult to undo later. What may feel like a normal obligation in one country can look very different under U.S. law, and the new rules make that distinction more important than ever. Closely connected to these changes is how the United States will now handle dual citizenship for people going through the naturalization process. If you are currently a green card holder planning to become a U.S. citizen, February 2026 brings important new requirements you need to understand in advance. For many years, the naturalization process has included an oath of allegiance that talks about renouncing foreign allegiances. But in practice, the United States has rarely forced new citizens to actually give up their original nationality. That basic policy is not changing. What is changing is how clearly the responsibilities of dual citizenship will be explained and formally documented. Beginning in 2026, naturalization ceremonies will include explicit briefings about what it means to keep another citizenship while becoming American. New citizens will be informed about mandatory registration, tax obligations, travel rules, and reporting requirements before they even take the oath. Anyone who chooses to maintain a second nationality will be required to acknowledge in writing that they understand these duties. Most importantly, new citizens who hold another passport will have only 30 days after naturalization to register their dual citizenship in the new federal system. This is a major difference from the past when many people became citizens and never thought about their prior nationality again. Another point that will be made much clearer is that whether you can legally keep your original citizenship depends on the laws of the other country, not on U.S. rules. Some nations, such as Canada, the United Kingdom, France, and Mexico, openly allow dual citizenship. Others, like China and India, generally do not recognize it, meaning naturalizing as a U.S. citizen may automatically end your previous citizenship under that country's laws. These distinctions will now be explained up front, so new Americans cannot later claim they were unaware. The purpose of this change is not to discourage dual citizenship, but to eliminate confusion and make sure people fully understand the legal reality they are stepping into. If you plan to naturalize in the near future, learning how your home country handles dual citizenship before taking the oath is more important than ever. Political activity in another country is another area where dual citizens will need to be much more careful moving forward. Under current U.S. law, holding dual citizenship does not prevent you from voting in foreign elections, donating to political campaigns, or participating in normal political discussions abroad. Those basic rights are not being taken away. However, starting in February 2026, deeper involvement in foreign governments will receive far closer scrutiny than before. If a dual citizen accepts a formal role in another country's government, runs for elected office, or takes an official oath of allegiance to a foreign state, that action can raise serious legal questions in the United States. The concern is not ordinary civic participation. The concern is whether taking on an official government position abroad demonstrates an intention to place loyalty to another country above loyalty to the United States. In the past, these situations were often reviewed only if they were extreme or high profile. Under the new framework, monitoring will be more systematic and reviews will be more consistent. This does not mean that every dual citizen involved in foreign politics will face problems, but it does mean that accepting certain roles could trigger investigations, interviews, or even challenges to U.S. citizenship status. For most people, simply voting or being politically active in a personal capacity will not be an issue. The line becomes much more sensitive when someone holds public office, works in a diplomatic role, or represents a foreign government in an official capacity. If you are a dual citizen with ambitions to serve in government abroad, this is an area where professional legal advice is essential before taking any major steps. Understanding where that line exists ahead of time can prevent decisions that might create complications years later. The overall message is not that political involvement is forbidden, but that the stakes attached to certain types of involvement are about to become much higher. Families with children are another group that will feel these changes in very practical ways. Many parents don't realize that children born outside the United States to American citizens often automatically become U.S. citizens at birth while also holding citizenship in the country where they were born. Until now, that dual status usually stayed in the background unless the family applied for a U.S. passport or a consular report of birth abroad. Starting in February 2026, that quiet approach disappears. When parents apply for a U.S. passport or official documentation for a child born overseas, they will now be required to formally disclose whether that child holds or is eligible for another nationality. That information will be entered directly into the same dual citizenship registry used for adults. In practical terms, parents will become responsible for registering and maintaining accurate records of their children's dual citizenship status. If circumstances change, such as a child later acquiring an additional nationality or losing one, those updates may also need to be reported. For families that move frequently between countries or maintain deep ties to more than one place, this adds a new administrative responsibility that didn't exist before. The government has made it clear that tracking dual citizen children is important for several long-term reasons. As those children grow older, their records may be used for future passport applications, security clearances, government employment reviews, and even tax compliance once they reach adulthood. While this may sound overwhelming, there is a positive side. Having a clear, documented record from an early age can actually prevent confusion later in life, when young adults try to prove their citizenship status or navigate complicated international situations. The responsibility, however, will fall on parents to stay organized and informed. For families with newborns or young children living abroad, understanding these new obligations early can prevent paperwork problems that might otherwise surface years down the road. What used to be informal is becoming formal, and parents will now play a key role in making sure their children remain fully compliant under the new system. Another change that many people will not anticipate until they are directly affected involves family-based immigration sponsorship. If you are a dual citizen who plans to sponsor a spouse, parent, child, or sibling for a green card or immigrant visa, the process is likely to feel more demanding starting in 2026. Immigration officers will now look more closely at the personal circumstances of the sponsor, especially when that sponsor also holds citizenship in another country. In the past, simply being a U.S. citizen was often enough to move the process forward. Under the new approach, officials may examine where you actually live, how often you travel abroad, where you pay taxes, and whether you truly maintain a strong, ongoing life in the United States. The government's concern is with people sometimes called paper citizens, individuals who technically hold U.S. citizenship, but live almost entirely overseas and only interact with the U.S. immigration system when trying to bring family members to America. Dual citizens in that situation may now be asked to provide much stronger evidence of U.S. domicile and intent to reside in the United States. This could include proof of employment in the U.S., long-term housing, financial accounts, voter registration, community involvement, and other ties that show a genuine connection to the country. None of this means that dual citizens will lose the right to sponsor relatives. It simply means the burden of proof will be higher. For dual citizens currently living abroad who plan to sponsor family members in the future, preparation becomes extremely important. Gathering documents, maintaining clear U.S. ties, and keeping accurate records of taxes and residence can make the difference between a smooth approval and a long, frustrating delay. These new standards are not meant to punish anyone, but they do require more planning than many people are used to. Understanding that shift now allows you to organize your life in a way that keeps future immigration options fully open. One aspect of these changes that often surprises people is that while compliance requirements are becoming stricter, the government is also trying to bring more structure to the process for those who decide they no longer want to maintain dual citizenship at all. Some individuals, after learning about the new rules, may feel that keeping two nationalities is no longer worth the complexity. Starting in February 2026, the State Department is refining the procedures for renouncing U.S. citizenship to make sure people fully understand what that decision really means before they go through with it. Renunciation will still require an in-person appointment at a U.S. embassy or consulate abroad, a formal oath, and a substantial fee. But under the updated system, anyone requesting to renounce will first go through mandatory counseling. This step is designed to ensure that people do not make irreversible decisions out of frustration, confusion, or temporary financial pressure. During this counseling, individuals will be clearly informed about the serious consequences of giving up U.S. citizenship. Those consequences include losing the right to live and work in the United States, potential difficulty even visiting the country in the future, and major tax implications such as the possibility of an exit tax on worldwide assets. Once renunciation is completed, reversing it is extremely rare and often impossible. At the same time, some dual citizens may decide that it makes more sense to give up their foreign citizenship instead. Many countries allow their citizens to renounce nationality voluntarily, although the process and difficulty vary widely. Some nations require lengthy paperwork, interviews, or proof of another citizenship, while others make the process relatively simple. Beginning in 2026, the new Dual Citizenship Registry is expected to provide clearer guidance about how renunciation works in different countries so people can better understand their options. The key point is that these decisions should never be rushed. Whether someone chooses to keep both citizenships, give up one, or remain fully dual, it must be done with full knowledge of the legal and personal consequences. The updated procedures are meant to protect people from making life-altering choices without truly understanding what they involve. So, what should you actually do right now as February 2026 approaches? The most important mindset is preparation over panic. Dual citizenship itself is not under attack. It remains completely legal and continues to offer enormous benefits from easier travel to expanded opportunities and deeper connections across borders. What is changing is the level of responsibility that comes with it. The first practical step is awareness. If you or anyone in your family holds more than one citizenship, mark the upcoming deadlines on your calendar now. Gather important documents early, including foreign passports, proof of naturalization, travel records, and any information related to foreign employment or military service. When the registration system opens, plan to complete it as soon as possible rather than waiting until the last minute.